non-compliance with the mandatory requirement of law as mandated under section 26 of clause 4. Well, audio, video. Where is the audio? Where is the video? Nothing. They have taken away the protection that is given to an accused under the provisions of the POCSO. Had it been there, probably your lordship would have been certainly in a position to know whether the child has said so or not.
Because even the 164 statements are cyclostyle.
Cyclostyle.
That is shocking. Even before the magistrate, what the children have said, ella cyclostyle.
Only issue
Repeat.
subject to senior counsel.
Yes.
Well, now, I think I need not labor much on this point. When law prescribes, my lord,
A thing to be done. Shall be done. or not.
otherwise
Yes.
it will have invalidating consequences. Is law that is being laid down by your lordship time and again, and also by the Honorable Supreme Court. I need not lay down. When once it is a shall, it means it is not directory, it is mandatory. It is mandatory. No, my lord posed a question to me. Where is the medical examination report? May I now invite your lordship's kind attention to section 27 of the Act. Violation after violation.
Medical examination of the child.
The medical examination of a child in respect of whom any offense has been committed under this Act. When you are prosecuting me, when the allegation against me is under section 7, which is made penal under section 8 of the Act, any offense, whether there is injury, no injury, let the doctor say no injury. You can't say that I will not subject myself for medical examination. Adan torstini, carbon copy adannuve. Ellaru idaralla 8 jana, 8 janadu carbon copy. But now here kindly see, in respect of whom any offense has been committed under this Act, shall, notwithstanding that a first information report or a complaint has not been registered for the offenses under this Act, be conducted in accordance with section 164 capital A of the Code of Criminal Procedure. Compulsory, madlebeku. Violation, again invalidating consequences. But why they don't do it? Your lordship would get from my compilation of the charge sheet. May I just request your lordship to kindly turn to reading page 57 and onwards. But I just now took your lordship to the 161 statements.
Yes.
Adral.
They are the statement.
ಇದು ಇವ್ರು ಬರ್ಕೊಡೋದು ಎಲ್ರಿಗೂ ಅದೇ ಒಂದೇ ಕಾರ್ಬನ್ ಕಾಪಿ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬೇಡ ಅಂತ. All would come into existence on 1st of October 2018.
1st of October.
1st of October 2018. ಎಲ್ರಿಗೂ ಒಂದೇ ದಿನ. ಏನ್ ಹೇಳ್ತಾರೆ? Reference to your notice dated 1/10/18. ಅವತ್ತೇ I hereby decline medical examination of my daughters. So and so, so and so. They are aged 9 years. They are not been bruised or injured physically. I do not want to cause mental harassment. Next to other, age 9 years. He has not been bruised and injured physically. I do not want medical examination. Next to, how does each ಗೊತ್ತಾಗಬೇರೆ bruise ಇದೆಯಾ ಬೇರೆ injury ಇದೆಯಾ ಎಲ್ಲರೂ ಒಂದೇನಾ? Every page. Well, this is again a flagrant violation of the mandate of law as mandated under section 27 of the Act. This would be my next legal submission. Well, subject to what my lord would ultimately say. Well, no sooner the court takes cognizance of the offense, and within 30 days, that is what the law mandates. The trial court shall record the evidence. May I request your lordship to kindly turn to section 35.
Yes.
The evidence of the child shall be recorded within a period of 30 days of the special court taking cognizance of the offense and reasons for delay, if any, shall be recorded by the special court.
Yes.
ಏನಿಲ್ಲ. For years together it is getting adjourned.
ಅಲ್ಲ ಇಲ್ಲಿ ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ.
ಈಗ ಬಂದಿರೋದು ನಾವು 2022 ನಲ್ಲಿ, ಇದು 2018.
ಅವಾಗಿಂದ ನಡೀತಾನೆ ಇದೆ.
ಅವಾಗಿಂದ ನಡೀತಾನೆ ಇದೆ. This is again violation of section 35.
Yes.
Lord, if my lord is persuaded to accept my submissions, right from the date of taking of cognizance of the offense, That also we do not find. We have to presume that he has taken cognizance of the offence on the 17th of December 2018 or 18th of December 2018.
Why, what was the motive behind the
But
complaint?
yes, my lord, it is an apartment
Hmm.
where number of flats are there.
Hmm.
In one floor, 6 flats are there in one floor.
Hmm.
Well, in 2 of the floors, my lord, the informant has been running a PG hostel.
You have objected to it.
I objected to that. And the resultant effect is I am prosecuted. My lord,
Where do you get that pleading is to that effect is there?
leading ಇಲ್ಲ ಫೋಟೋಸ್ ಇದೆ ಅಂತ ಕೊಡ್ತೀನಿ.
Photos.
ಅಲ್ಲ PG ನಡೆಸ್ತಾ ಇರೋದು.
ಅಲ್ಲ ಅದು pleading ಇದೆಯಾ?
ನಾನು ಕೇಳಿದೆ ಅದನ್ನ ಅವತ್ತೇನೆ. ಒಂದು ಪ್ಲೀಡಿಂಗ್ ಬೇಕಾಗಿತ್ತು ಅಂತ
Hmm.
ಅವಶ್ಯಕತೆ ಇತ್ತು.
Because finally, if you have to answer motive, it seals. Then we will hear the additional SP.
ಪ್ಲೀಸ್
Yes, sir.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಇನ್ಯಾವುದಿದೆ sir?
ಅಲ್ಲ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಓದ್ಬಿಡ್ತೀನಿ ನೋಡಿ. ಏನು ಎಲ್ರದ್ದು ಅದೇನೆ.
Which?
Yes, your lordship may kindly turn to page 80 of my petition.
18.
80.
80.
Typed copy, you will not 82. Well, does it not defy elementary logic and common sense, my lord?
ಇಷ್ಟೇನಾ?
ಇಷ್ಟೇ ಏನಿಲ್ಲ ಒಬ್ಬರಾದ್ಮೇಲೆ ಒಬ್ರು ಬರ್ತಾ ಇದ್ರಂತೆ ಕತ್ಲೆನೆಲ್ಲ ಸಾಲಾಗೆ ನಾನು ಸ್ಕ್ರೀನ್ ಇಂದ ನಿಂತ್ಕೊಂಡಿದ್ದಂತೆ ಎಲ್ಲರನ್ನು ಮುಟ್ತಾ ಇದ್ದಂತೆ ಇನ್ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಆಗಿ. I can understand one, I can understand two, not all. And next day complaint.
Who is the complainant?
Well, the complainant is the father
Of
of one of the child.
one of the child.
Yes,
Speaking for every child there.
he speaks for every child.
And where is the charge sheet?
I'm sorry, madam.
Charge sheet?
Yes, your lordship will get the charge sheet.
31.
30?
1.
I have given the full set of the charge
Yes,
sheet
yes.
along with the memo, my lord. This column number 7, it commences at page 31, my lord. 31,
Yes.
column number 7.
And it is continued at 35.
Yes. It continues at page
35.
25 ಮಕ್ಕಳು
Yes, sir.
The issue of taking cognizance, my lord. The record says first, with respect to non-furnishing of document, medical report, FSL report, it was not there. So therefore, the court may have sought for it if it is there. Your lordship may see the charge sheet itself says that medical report is not there. Therefore, FSL report is also, it cannot be a.
Well, medical report ilve illa. Examination ಆಗಿಲ್ಲ. What report?
Therefore, though the court said, my lord, probably it mechanically sought for a report in case, since it was absent in the charge sheet, probably mechanically they sought it, but it has no consequence of present case in hand. Because what is required in this case is only the statements and the 164 statement recorded during the course of
ಇಲ್ಲ
investigation.
cyclostide. 164 statement to cyclostide.
Your lordship may see the incident. It's not that incident happened at multiple locations. Incident happened at one place
One location.
and one time. So action is that he is touched them inappropriately at wherever this thing.
That is what the complaint says.
The correct, my lord. So that is what 161 statement. I can understand, my lord. 161 statement is verbatim, as senior counsel has read out it. 164 statement.
Even that is verbatim. Nodi.
I've seen that.
See.
Yes,
Even that is the same.
but the fact that, my lord, at least
That is precisely why I saw the 164 statement
Lord,
also. Nodi ನೀವು.
English Kannada ಎರಡು ಇದೆ.
The English ಅಲ್ಲಿ ಇರೋದೇ ನೋಡಿ.
ಎಲ್ಲರಲ್ಲೂ it's
ಎರಡು
similar.
ಒಂದೇನೆ.
The issue is that he has touched them when they were playing. So if it is in a different location, if it is a different victim, a different time zone, this we could have said it, my lord. It maybe some
What
doubt.
do you say about gross procedural violations?
With respect to that, my lord, there is they are not. Ultimately he can take benefit of those things if it is against this thing. The only issue
In a trial.
wherever it is provided.
In a trial.
In a trial, wherever it is provided, shall. It is not necessary. Of course, it's mandatory, but
No,
wherever it
that's-
is provided.
It's wholly penal. It should be, even if it is may, it should be read as shall only.
Like that language also used, my lord, wherever it is provided. So therefore, it is not that. Of course, he can take the benefit if it has not been done during the course of trial. But at this stage, my lord, when evidence has been begun, charges have been framed. Of course, there is an issue with
Is that the way to frame charge?
Uh,
What happens to 227, 228? All those procedures